There have been sweeping changes to Florida laws in response to the condominium building collapse that happened in Surfside, Florida back in 2021. In this video, I'm going to talk to you about those changes in the laws and how they're going to impact buying and selling condominiums in Florida. Welcome back to the Crazy About Condos channel. I'm Kris, and on this channel we talk all about condominium living in Sarasota, Florida. While it is sad that it takes a devastating event like a building collapse to make people stand up and take notice, it is a relief that the changes are finally here. If you're a condominium owner in Florida, you should be concerned about these changes. The results of these changes are going to be painful, but they are necessary. So now more than ever, I encourage you to get involved with the board of directors in your association. Attend the meetings, read the meeting minutes, vote on the issues that are presented to the unit owners, and be crazy, run for the board yourself, but know what's going on, be involved. So when I think about a person who's sitting on a board of directors in a condominium association, I'm envisioning a homeowner, just a plain homeowner with no special training or experience in running an association. And that homeowner, quite naturally, is motivated by keeping the costs as low as possible for running the association and taking care of everything that needs to be taken care of. Unfortunately, though, in that pursuit, some poor decisions get made. Needed repairs and improvements are ignored. They are put off beyond the time when they should be done. Or they are performed, but they're performed with substandard materials. And we saw the results of that kind of thinking in the Champlain Towers in Surfside. It resulted in the building falling down. So that's not a good way to go. So the changes that the Florida Legislature made in May of 2022, which was just under a year after the building collapse, affected two chapters of Florida statutes. Chapter 553, Part 4, which is the Florida Building Code, and Chapter 718, which is the chapter of the law that deals with condominiums and co-op properties. Now, I'm not an attorney, I'm a realtor, so I'm not allowed to interpret these changes in the law for you. However, I was able to get a summary of these changes that was written by a Bradenton attorney named Curtis Hamlin. Now, Curtis is a partner with Porges, Hamlin, Knowles, and Hawk. And he specializes in condominium law and real estate law. So I kind of trust what he has to say. So I'm going to start with the changes that were made to Chapter 553, Part 4, as written by Curtis Hamlin, attorney. And he says, mandatory structural inspections for condominium and cooperative buildings. This is the language that creates the milestone inspection. Remember that term, milestone inspection. Requirements for condominium and cooperative buildings, 3 stories or more in height. That's another important thing to remember, 3 stories or more in height. Who can do these inspections and timing based on the issuance of a certificate of occupancy and the proximity to a coastline. It goes on to say that the milestone inspection must be performed within 25 years of the certificate of occupancy if the building, 3 stories or more, is within 3 miles of the coastline, and 30 years after the certificate of occupancy if it's more than 3 stories from the coastline. As a realtor, I practice in Sarasota, Bradenton, Venice, Florida, the Barrier Islands, where there are a lot of buildings that are 3 stories or more that are real close to the coastline, and definitely within 3 miles of the coastline. So these milestone inspections are going to impact a lot of buildings in my market. Now, he also goes on to say that if a milestone inspection is required under this section and the building certificate of occupancy was issued on or before July 1st, 1992, the building's initial milestone inspection must be performed before December 31st, 2024. Now, I'm recording this video in July of 2022. So that means that there is just less than 2.5 years for all of these buildings in my market to have milestone inspections performed. That's going to be tough. There are going to be a lot of inspectors who are real busy. And those inspection reports have to be reviewed by an engineer or an architect. And those engineers and architects are going to be extremely busy in the next 2.5 years. I mentioned there were also changes made to Chapter 718 of the Florida statutes, the chapter that deals with condominiums specifically. And the changes that were made to that chapter include the requirement of a structural integrity reserve study, or an SIRS. And I'm going to read right out of the statute to tell you what that's all about. Structural integrity reserve study means a study of reserve funds. Now, step back a minute and make sure you understand what reserve funds are. Reserve funds are a savings account that's maintained by the community association for repairs, improvements, maintenance of the property. So it's saying a study of the reserve funds required for future major repairs and replacement of the common areas based on a visual inspection of the common areas. And it goes on to talk about who can perform these studies. And then it says, at a minimum, a structural integrity reserve study must identify the common areas being visually inspected, state the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense of the common area being visually inspected. So the reserve study is to figure out how much money needs to be in the reserve account for the association. And if you read a little further in Curtis's summary, he says, effective December 31st, 2024, the members of a unit owner controlled association may not determine to provide no reserves or less reserves than are required by the subsection for the items listed in paragraph G, which I'm going to mention next. So the associations are going to have to somehow come up with the reserves that are going to be required based on this structural integrity reserve study. That could mean a lot of money for some associations. And here are the components that must be included in the study. The roof, load-bearing walls or other primary structural members, floor, foundation, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, and then this little catch-all at the end, any other item that has deferred maintenance expense or replacement costs that exceeds $10,000, and the failure to replace or maintain such item negatively affects the items listed above. So that's a pretty comprehensive list, and that's going to take a lot of time to not only have the milestone inspection that we talked about for Chapter 553, but to have the structural integrity reserve study to figure out all the dollar amounts that are going to be required. Now, the laws, of course, that were changed are much more complex than my summary here in this video. So another thing I would encourage you to do if you are a unit owner in a condominium in Florida is make sure that you and your board are in touch with your legal counsel and make sure that you are completely in compliance with these changes. So now you're aware that certain condominium associations are going to be required to have the milestone inspection report and the structural integrity reserve studies by December 31st, 2024. So between now and that date, there's going to be kind of this honeymoon period during which these associations are going to be in the process of getting these reports, having them reviewed by the appropriate engineer or architect, and distributing the information to the owners, responding to how to collect the reserves and so forth. So during this time, there's going to be a bit of uncertainty that's going on in these community associations. And buyers who are faced with uncertainty are going to be a little hesitant to buy. That may have a downward pressure on values. And there was something else that happened in 2022. The mortgage giants, Fannie Mae and Freddie Mac, sharpened their pencils and they added 3 pages to what's called a condo questionnaire. Now, condo questionnaires are required by the lenders. They send them to the association to be completed and then ask a bunch of details about the community association. And those additional 3 pages are all about structural integrity reserve studies and inspections. They were even ahead of the Florida Legislature in asking for that information. The responses to these additional questions by the association may not meet the lender requirements, particularly if inspections have not been performed at all, or particularly if it's decided that the reserves are not adequate for the required repairs going forward. That may result in a denied mortgage application, and it may render the entire condominium complex unable to be financed by mortgages. When that happens, you're limiting the pool of buyers that are going to be able to buy in that community, and that has a tendency to put downward pressure on prices. So if you're a seller of a condominium unit, be aware of that fact and lean on your realtor for the right advice. And whether you're the seller or a buyer of a condominium unit, know that there are other documents that you need to provide or receive that are related to the condo community. And if you want to know what those documents are, watch my video called Condo Documents You Need. Until next time, see ya.